Parental alienation is one of the hardest things to prove in family court, and also one of the questions I get asked the most. So in today's video, I'm going to walk you through how do you prove parental alienation in family court. So the first thing we're going to look at is, what evidence do you need to gather in order to prove parental alienation? So I would just start gathering evidence as soon as possible. As soon as you acknowledge that there's an issue, then just start gathering evidence, whether that be text messages, videos, emails, statements, yours, theirs, reports, all of it. Just gather it all and start popping it in a place, and I'll talk about that next. But just start gathering evidence. Also, just be mindful of how you present in your evidence. So if you've allowed your anger to get the better of you at times and your frustration, rein that in. Because if you're going to show evidence, it has to show you in the best possible light. So don't react to their baiting. Don't come across as being controlling. Just be mindful of the narrative that is going to be told about you, and don't be that guy or girl. Be emotionally regulated. Be polite. Be brief, informative, friendly, and firm. So, like I say, not controlling, assertive, but friendly. And I don't mean friendly like pally. I just mean as if you were talking to a colleague at work, maybe a colleague you don't like at work, but one where you know you've got to be civil and, make it look as though everything's okay. So just be mindful of that if you're going to submit evidence of videos, audio recordings. It's not just you. It's not, if you're gonna show them in a certain light, be mindful of how you're going to be shown as well. Remember that parental alienation is also more than one type of abuse. It's also coercive control of you and emotional abuse of the child. So just start thinking about those types of evidence as well. So not just the alienating behaviours, but these other types of behaviours. If you're going to prove alienation, you need to prove it within this pattern of personality. And so look at where it's been coercive controlling in the relationship, financial abuse, isolation, controlling what you can do, who you can speak to, that kind of thing. Just be mindful of that, include that. And obviously emotional abuse of the child, which alienation is, but there's going to be other things included in that as well, such as not letting them have their own friends, deciding what sports or activities they can do, that kind of stuff. Then go through the specific behaviours, looking at the framework, the legal framework. So you can look in the Domestic Abuse Bill guidance and what they call alienating behaviours. There's also a consultation document that is closed now, but you can still have a look at it, and it lists out what the Ministry of Justice see as being alienating behaviour. So use that as well. And you can also look at the Child Impact Assessment Framework on CAFCASS's website and look at what they think alienating behaviours are. And they break it down into your behaviour, your ex's behaviour, or the alienating parent behaviour, and the child's behaviour. So just start to think about evidence and how it fits into that framework. Now, just talking about that consultation document, it's not great for alienated parents because it puts the burden of proof on you rather than the other person having to prove why contact has stopped. You've got to prove why you think contact has stopped because it's alienation. And also what evidence you can prove. So like I say, I recommend having a read through just so that you're aware of where they're at. These changes have not been made, but it's always worth knowing the landscape that you are in. Proving allegations can be really key in this. So false allegations are always part of a narcissist playbook, and they're always part of alienating behaviours. So if you're able to prove that what they're saying is false, it is a false allegation, you can then start to, along with all the other behaviours, start to say this is a strategy that they are using to undermine me as a parent and as a person, so my credibility, not just in court, but also, in my job, in my relationships, all of it. And this is all part of a deliberate campaign to discredit me and to be malicious towards me. And I use a 3-step kind of approach to this, which is they knew that it was a false allegation. They know it's false. Can you prove that? Can you prove that it was done with malicious intent, i.e. what did they benefit from making this false allegation? And what impact has it had? How has it harmed you? How has it harmed the child? How has it harmed the case and the process? So that's the 3-step process I tend to work through with false allegations. So then what do we do with this documentation? How do you organise into alienating behaviours? So I have developed something called Evidence Tracker, and it's part of our Master Your Evidence course, which is free within our Court Prep Toolkit. And it's essentially multiple spreadsheets, all designed to walk you through the process. And there's particular ones for alienation, false allegations, coercive control, emotional abuse. It's all broken down for you, including all of that and everything. It's all there. Every step of the process is there with a different spreadsheet to help you take your information. So that running a record, and then you can use that information across to analyze the behaviors. Now you can use your own system, whatever that looks like for you. What I would start doing is, like I said before, break this down into specific behaviors. So for the court, what you need to be doing is, I would always be thinking sort of like fact find level of what are the main themes in this. And usually in alienating behaviours, it is coercive control, emotional abuse of the child, false allegations, and alienating behaviours. So there might be other ones that are specific for your case, like emotional, medical neglect, or physical abuse or sexual abuse. It could be anything, but just start fitting your evidence into those categories, and they're going to cross. Some of them are going to be emotional abuse and something else. So do it on all of them. In Evidence Tracker, we have this tick box system, and then we have an analysis category whereby we talk about the specific. So under alienating behaviours, we'll tick it's an alienating behaviour, but then in the analysis column, we will say it's bad mouthing or making unilateral decisions, or controlling contact. So we then start to form that into a one long running record of all of your evidence. It can be useful for later. You can have what type of evidence it is and a name, so the name that you use, you can then link to the document. Anyway, so that would help going forward with writing statements and everything. But you need to be very clear from the start what it is that you are evidencing. And so breaking it down into those themes is really important. Next is, how do you get professional support to help you prove parental alienation? And I'm going to break this down a little bit. So my advice is the first level or the first layer of professional support is actually for you. Now, I would always recommend therapy, because this is hard. This is like one of the most painful things you'll ever have to go through. You're experiencing grief, anger, frustration, or just such a whirlwind of emotions. And if you're in this situation, you probably haven't been taught as a kid how to regulate those emotions, what to do with them. So either bottle them down, in which case they might pop at a really inopportune moment, or you're like a grenade going off all the time, crying or shouting. These are all trauma responses, but in the court, they're going to be used to try and form a narrative of you. So A plus B equals C. They're saying you're aggressive, you're angry because nothing's working out for you. You're sad, really, under it, you're sad. There's a lot of other emotions under that anger. When you express anger, they're going, oh, look, he must be aggressive, or oh, look, she must be emotionally unstable. So it's being mindful of that. And when you have therapy in a safe space, you can learn to regulate your emotions. You can offload onto the therapist who understands and is non-judgmental. And it's a safe space for you to do that. Now, it doesn't have to be a therapist. I run a therapy firm which is specially designed for this, and the nurturing coach. You could find a support group. I know Parental Alienation Awareness in the UK, they do in-person support groups around the country. There are online support groups as well. Just find a safe space for you to offload, but learn how to regulate your emotions, because your ex is going to be pressing your buttons, and learning to regulate your emotions not just helps your case, it helps your children, and it helps you. Because when we can't regulate our emotions, we have a really difficult time with it. And I'm, speaking to someone who's had that problem. I'm learning all the time how to do this. So no judgment, but learn. For your children, it will change their lives. It will make sure that they know that you are that secure base for them. So the next layer from that will be support for your child. So either might be a nurturing group within school, or it might be a therapist for them, or it could be a therapist for you and them. Make suggestions. If you're not seeing your children at all, this is the sort of things you can ask court to offer for the child, because you want them to have that safe space. Like, you need a safe space, they need a safe space away from the alienating parent. Now, obviously the alienating parent is going to want to interfere in that and try and control it, because that is who they are. But again, that will be evidence going forward of how they aren't child focused. Actually, it's about control for them. They don't want their child to see a therapist. We know, because they don't want the kid to say anything that might get them in trouble. They don't want the family secrets to be revealed. So they don't want outsiders looking in and raising questions. So any attempts that they make to block the access of the children to therapy, you can use as your evidence. But ideally, your kids would be getting that. Next level of that is CAFCASS and guardians. They happen through the process anyway. CAFCASS will always become involved as soon as it goes to family court, because they'll do a safeguarding check. For some cases, that's all they would do. For cases like yours that involve alienation, there will usually be a Section 7. You can request that at your first directions hearing. It's about proving that it's complicated, and there needs to be more of an assessment of what's going on here. 9 times out of 10, that will be given anyway. Section 37 is when the court recognises that the child has experienced harm. Now, whether they're saying harm that you've caused or harm your ex has caused, that will depend on how the rest of the hearings have gone. But Section 37 is another opportunity to present these risks, and obviously any false allegations and what they will mean at a deeper level. Section 37 is a deeper assessment. Next, it is a part 25 expert witness. So a psychologist to come and assess family dynamics. Now, there's new guidance been brought out recently on what experts need to be, what constitutes an expert. So again, get familiar with that, and make sure that you understand that they need to be with a particular regulatory body and have particular training, be called a particular thing. Understand all of that. So if you are given the green light to put forward some names, you are checking that they tick those boxes. Because what you don't want is to get a psychologist, come in, say, yes, it's alienation, and then your ex goes, well, they're not an expert according to the guidance because blah, 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 blah. Get it right from the start. Now, the court should help you with that, because they're bound by that as well. But just to cut down the opportunity for it to go wrong, make sure you get it right from the start. Obviously, some people, because they know this process, they want the expert to be involved straight away. That it just doesn't happen like that. The court needs to figure out for themselves that they need an expert. Your job is to just keep showing that you do. Keep showing that things aren't as they seem. Things aren't black and white. That all the procedures in the world that CAFCASS might have, or that family court might have, aren't going to fix this. And so we need someone to really get into the mindset and the understanding of what is going on here. Particular specialities that you're looking for are people that understand trauma, attachment, family systems, and personality disorders. I'd aim for all of them. If not, I would personality disorders be the one that you could potentially knock on the head, because psychologists should understand those things anyway. So finally, what legal strategies can you use to address parental alienation? So as I talked about, one of the main things is don't be what they're accusing you of. So know their narrative of you. Think about how that person might present, and don't be that person. Get support with that. Get a strategy. Work with someone like me, or there's lots of other coaches out there who you could work with to really understand how you want to present yourself and your case going forward. That will massively help you, not just in the practical sense, but also in the emotional sense of feeling you've got someone on your side. You've got someone who gets it, someone who can help you. When something comes up, you can chat it through to them. What do I do? Do I do this? Because obviously you've got complex PTSD. You're not always going to trust every decision that you make. And so having someone else is really helpful to be able to balance that off. And like I say, someone with an expertise in narcissistic behaviours and parental alienation will really help you to be 2 steps ahead, I guess is what I'm trying to say, to know what they're going to do, understand their psychology, so that you can counter it or stop it from getting too much momentum. So do try mediation. It is unlikely that it will go anywhere, because your ex will either refuse to do it with you because you're such a horrible person that they can't possibly be sat in a room with you, or they hold all the cards. So what's the point? Why would they bother going to mediation? They don't want anything to change. You're the one that's got a problem. Use it as evidence. You could also ask for child-led mediation, which is when your child is involved in that. You'd want a really good mediator, and ideally someone that might understand the signs of a child being emotionally manipulated. It comes with risks, but again, it's something for you to consider. Once you've got your C100, which is when the mediator signs off on mediation, you can then go to court. You might want to consider a C1A form, which is around abuse allegations. It could be, if your ex has already put one in, you've got to respond to them. Or it could be that you are putting one in first. So if you're responding to them, I would be looking at, like I said, coercive control, emotional abuse, and then how these allegations fit into those categories. If you're putting one in first, make sure that you've done the evidence work first. So make sure you've organised your evidence before, because what you want to do is only present evidence that you can 100% prove, your objective evidence. The subjective evidence that you have will come later in the process, but from the off, what you want is stuff that you can absolutely categorically say did happen. So next up will be your CAFCASS section 7. You can ask them to assess for alienating behaviours using the child impact assessment framework. I would also be asking for a fact find when there's false allegations, because you need a factual matrix. If you're going to be talking about contact and what's best for the children, you need to know what's really gone on here. So we need a factual matrix. I would also ask for it to be upgraded to a district judge, because magistrates just don't have the training to be able to understand this level of psychological component within these cases. You'd probably get a no to start off with, and you might want to consider it as part of the longer term strategy, as in you're building towards it. So you maybe don't ask in the first hearing, but that's where you want to go. So how do you in the first hearing just start to prove that that's what's needed? But at some point you probably are going to have to ask for these things. So it's being consistent in why. Now, obviously, CAFCASS are going to do their initial checks and ask why it's in court. Why can't you agree? What do you think's going on here? Be child focused. Don't use it as a opportunity to badmouth your ex. Just be clear on what you think's happening to your child and why you're looking for the court to help protect your child, and put the children's needs paramount. I hope you found that helpful. I recommend taking a look at the website www.getcourtready.co.uk. I've got a range of resources on there which are useful for you. I also recommend our court prep toolkit, which walks you through the entire stage of the process. Know what to expect from your ex, from the process, what their psychology is and how you can use their weaknesses against them, how to present your evidence using our Master Your Evidence and evidence tracker, and how to heal. It's got PTSD tools to help you manage your emotional regulation. So I'll leave the links for that below. Don't forget to like, comment and subscribe, and share with anyone you think would benefit. So take care, everyone.